Any child who's in distress is going to be of great concern to us. Where that child is experiencing mental health distress, our concern will only deepen. And where that mental health distress happens in a context where a child may have experienced earlier childhood trauma, that concern deepens to great sadness and great concern indeed. Now, I think it can be fairly described as being a universal principle that all children should be afforded a happy and a healthy childhood. Yet a simple Google search will bring you to the UK Mental Health Foundation, which provides some very interesting and stark statistics. It says that 20% of adolescents may experience a mental health problem in any given year. 50% of mental health problems in young people are established by age 14, and 10% of children and young people aged 5 to 16 years have a clinically diagnosable mental health problem. So to put that in a context, any of you that have children that are going to school, the average class size would be 30 or 33. So at least 3 of the children in your child's class are going to experience mental health diagnosis in their lifetimes. So that's quite a significant statistic. And perhaps most significant of all, and while it may apply to the UK, I don't see any reason why it shouldn't also apply in Ireland, is that 70% of children and adolescents who experience mental health problems have not had appropriate interventions at a sufficiently early stage or age. So in that context, we can consider the range of mental health difficulties that young people experience to be along a spectrum of seriousness. And today we're going to hear from 2 speakers from 2 organisations that provide services to young people in distress. And then we'll hear from 3 other speakers who are all lawyers who practice regularly in the area of child law. These speakers will speak to the practice of treatment and intervention and to the legal procedures with regard to involuntary detentions and also to the legal safeguards that must be observed when we're dealing with these matters. Now, the state provision of assistance is provided by the HSE-funded various child and adolescent mental health services across the country. These services provide much-needed community-based specialist mental health treatment and care for young persons up to age 18. The service is delivered by multidisciplinary teams, and later today we're going to hear a clinical perspective from Dr. Jerry McCarney. I think it's fair to comment that the CAMHS services, while they are so essential and important and necessary, are not without their limitation. The availability of services varies throughout the country, and not all CAMHS services accept referrals of children up to 18 years of age. And there would appear to be different protocols for the acceptance of referrals for young people aged 16 and 17 across various services throughout the country. And also there's no national protocol available for CAMHS services. Of particular concern is what might be perceived to be the lack of the ability of CAMHS to react in acute situations, as the services have been established as a GP referral only service. And in the case of an emergency outside the usual business hours of Monday to Friday, 9 to 5, a referral to a local accident and emergency department may be the only viable option for a young person who has a mental health crisis. According to the HSE Performance Assurance Report of 2014, by the end of December 2014, 1/3 of children and adolescents under age 18 were admitted to adult wards that year. There's still no dedicated forensic mental health inpatient service for children and adolescents in Ireland, and many young people with significant and serious mental health difficulties are placed for care and treatment in institutions and situations in the United Kingdom. The vehicle used to facilitate this is increasingly the wardship procedure, and the National Safeguarding Committee report on wardship in an adult context, which was published in 2017, made certain criticisms of the wardship process, including the lack of the voice of the person involved in the wardship, the lack of procedural safeguards perhaps, and also the over-reliance on the good office of the committee or the solicitor to ensure safeguards for the person who's at the centre of the proceedings. And I think it would be, while the committee made these criticisms on the adult process, these criticisms apply equally to the child process or to the minor process. And I would certainly hope that our legal speakers during the course of the afternoon will return to these themes and address them to you more fully. Our first speaker today is going to be Siobhan Lejan, of Pieta House, who's going to speak to her experience at Pieta House, working with children and young people experiencing mental health problems. And as we all know, Pieta House is a not-for-profit that provides free therapeutic service to children, young people and adults who are experiencing suicidal distress or engaging in self-harm. In situations where a child needs treatment and valid consent to admission or treatment is absent, all applications for an involuntary admission to care must be made to the district court. This reflects the extremely wide jurisdiction of the district court with regard to children generally. Section 71 of the Children Act creates the Children Court and directs that the district court, when hearing charges against children or applications, various applications under the Child Care Act, shall be acting as the Children Court. The Children Act of Section 75 of the Children Act allows the district court what may be considered to be a wide discretion to deal summarily with offences where a child is charged with indictable offences. And the Child Care Act of 1991 allows the district court to take a child from the care of her parents and place her in the care of the Child and Family Agency for various periods, including for the full duration of her childhood. And it's only applications for special care and protection and applications for wardship that are retained by the High Court. So, in this context, if a child is likely to come into contact with the justice system, it's most likely the district court that the child is going to come into contact, or where this will occur. And it doesn't appear to be a coincidence that the lawmakers have taken this approach to the jurisdiction question. We're going to shame you by silence while you take your seats.
I had to do this without directions.
Very good. So it's not a coincidence, I think, that lawmakers have taken this approach to the jurisdiction for dealing with children. The motivation for the approach, I'm not going to speculate upon, but it is clear that each of these important areas where children come into contact with the law require specialist attention and knowledge, and also require a sensitivity in approach to ensure that the voice of the child is adequately and properly heard in these proceedings. And there's much goodwill from the judges of the district court to do this work. However, we're largely untrained to do this. And perhaps this deficit will be addressed subsequent to the passing into law of the Judicial Council. The Judicial Council will be charged with establishing and providing education and training to judges. And this would seem to me to be an important area of training that council could address. Now, not all of the children that I referred to earlier in the rather startling statistics that I mentioned will suffer from a mental disorder to such a degree as defined in Section 3 of the 2001 Act. However, as we all know, there are occasions where young people are suffering from a mental illness or an intellectual disability to such an extent as to be likely to cause themselves or others immediate and serious harm, or where by virtue of the extent of their illness or disability, their judgment is so impaired and a failure to admit would likely lead to a serious deterioration in their condition or would prevent treatment, and that detention and treatment would be of benefit to them. Section 25 of the Mental Health Act sets out a detailed procedure which must be followed before a child may be detained without their parents' consent or without their consent if they're aged 16 or 17. And Catherine Kelleher, a solicitor who will be known to you all, will speak to us with regard to the technical safeguards contained in the Act later today. These safeguards are necessary to protect the child's constitutional right to personal liberty and to have their views taken into consideration, and also to protect the child's various rights under international conventions: the European Convention on Human Rights, the Charter of Fundamental Rights, the UN Convention on the Rights of the Child, and the UN Convention on the Rights of People with Disabilities. These fundamental rights have been considered in various cases that have been decided by the High Court and the Court of Appeal in recent years, and we will be lucky enough this afternoon to have Natalie MacDonald, Barrister at Law, and Alan Brady, Barrister at Law, to speak on the interplay between these protections and the statutory framework, and to guide us through the decisions of the Superior Courts later in the day. So I'm sure, having looked at the timetable, you're going to agree that we're going to have a full and an exciting seminar ahead. Before we proceed and hear from our first speaker, I'm going to ask that you all make sure that your phones are switched off. I don't have a court guard today who's empowered to seize them, but Mr. Lennon is on the premises, so you can take your chances. Also, we have a very full programme. Each speaker will be allotted approximately 30 minutes. So I am going to try and keep speakers to their time as much as possible so that we get an opportunity to hear from everybody. We will have questions and answers, but questions and answers will be retained to the end of the session. As I'm informed, there may be some difficulties with regards to consent. So in that particular context, if you do have questions, we'll save them until later in the afternoon. First of all, our first speaker was Siobhan from Pieta House, who gave us a really clear and good description of the work that she does and Pieta House do with young people and adults as well that are experiencing mental health problems. And we also heard from Dr. McCarney, who gave his very clear input on the clinical perspective of diagnosis and treatment and the decision-making process that clinicians go through before they come to a Section 25 involuntary detention admission decision. He also brought us the issues that are facing clinicians, which are very similar to the issues that are facing many of the professionals in the room. Then we heard from our three legal speakers today, or 2.5 perhaps. Alan was so late. We have been given the most clear and comprehensive overview of the structure of the 2001 Act. We've also been given a very clear outline of the protection of the fundamental rights that must be put in place in order to secure the rights of the children who are at the centre of these proceedings. We've been given very clear information about the interplay between the Mental Health Act and the Child Care Act, and that one can't be viewed or seen without the other. And we've also been given some very valuable information about the wardship process and how that's being used at the moment. Certainly, if there's some takeaway points from each of the sessions, it's with regard to the different perspectives that we all may have. We may be clinicians working at the coalface. We may be children at the centre of these proceedings. We may be parents looking for services for our children. We may be guardians who are involved in cases, or solicitors acting for guardians, solicitors acting for parents, or solicitors acting for the state agency who's responsible for acting promptly in these kind of situations. But whatever our different perspectives, it seems clear to me today that everybody in the room has the same goals. And it's important, I think, sometimes to realise that we are all working together and we're not working against each other necessarily. And indeed, the goal here, and it's coming across very clearly from each of the presentations today, is the protection of vulnerable children while respecting their fundamental rights, and that those safeguards are put in place at every stage of the decision-making process. This is for all of us, particularly for those of us who work in the district court at various different levels. As it's been pointed out, the judges in the district court have a very significant duty to ensure that the fair procedure rights and the procedural safeguards that are there in the legislation are enforced, perhaps on a case-by-case basis, knowing which responses may be correct in a particular case. But we do this on the basis of the arguments that are made before us. And so you as clinicians, you as practitioners, you as guardians, you as solicitors and barristers, you must draw our attention to what you think are the necessary safeguards and protections in the case that's before us at each and every time. So we all have duties and responsibilities in this regard. Catherine's perspective was extremely interesting with regard to the potential that's coming down the line with regard to the English decision. That could have a very significant impact on the number of cases that are going to come before the district court in the future. Indeed, the one thing that we haven't mentioned today, but that perhaps needs to be mentioned, and I'm going to do it, is what happens to all the children who are now currently in the UK if Brexit happens on the 31st of October. What is the Irish response going to be with regard to the placement of children with those kind of needs when the United Kingdom eventually does leave the European Union, as it seems it's going to do? These are hard questions that there's no easy answers to, but time is ticking by and we need to get ahead of this particular conundrum. So, on that note, I'm going to thank you all for your attention. I'm going to particularly thank our speakers today for all of their particular inputs, and I'd ask you to put your hands together one final time.